express their appreciation for the efforts of the Secretary-General's personal representative and to reaffirm their decision to continue to avail themselves of the good offices process in order to reach a final settlement as called for by the Geneva Agreement. Notwithstanding its repeated assertions of its commitment to a peaceful resolution, we're bound to say that the good offices process was unfortunately marred by armed military incursions from Venezuela into Guyanese territory on numerous occasions. This happened in 2007, in 2013, and in 2014. This resulted in the unlawful seizure and destruction of Guyanese property and the unlawful detention and abduction of Guyanese citizens. Again, Venezuela objected to investment and infrastructure projects in the Essequibo region, which of course undermined Guyana's development. By 2014, the parties were no closer to a resolution than they had been when the Secretary-General was first entrusted with selecting the means of settlement some 31 years earlier. 5 decades had now passed since the Geneva Agreement, with no meaningful progress. In the face of such failure, and confronted by a renewed Venezuelan campaign of threats, Guyana concluded that there was no point in continuing the good office process. It proposed, reasonably, that the Secretary-General should use other means of settlement as provided by Article 4, Paragraph 2 of the Geneva Agreement, with its renvoi to Article 33. And so, on December 2nd, 2014, Guyana notified Venezuela of its proposal. Venezuela recognized that the controversy must be resolved in accordance with the Geneva Agreement. In September 2015, UN Secretary-General Ban Ki-moon met with the President of Guyana and the President of Venezuela. He wrote to the parties to outline proposals for what he called the way forward. He explained that if a practical solution was not found before the end of his tenure, he intended to initiate the process to obtain a final and binding decision from the International Court of Justice. Until then, the Secretary-General pledged he would do his utmost to assist the parties to reach an agreement through the ongoing good offices process. Following his announcement, the parties and the Secretary-General's chef de cabinet met on several occasions. Regrettably, these were once more overshadowed by Venezuelan threats. In February 2016, for example, Venezuela's foreign minister reasserted rights over the Essequibo in a statement to the United Nations. In May of that year, Guyanese officials monitoring the Essequibo region of Guyana were shot at by Venezuelan armed forces. Multiple other military incursions into Guyana's territory were reported. You will find all of the evidence set out in full in the written pleading. And so, against a backdrop of escalating tensions, on December the 15th, 2016, Secretary-General Ban Ki-moon stated that it had proved impossible to bridge the differences between the parties. He announced what he called an extensive stocktaking of the good offices process. It would continue, in his words, for one final year, with a new personal representative and a strengthened mandate of mediation. Thereafter, and significantly, the Secretary-General of the United Nations set out a clear condition to underpin a time-limited extension, and you will find his words at tab 18 of the judge's folder. He said, if, by the end of 2017, the Secretary-General concludes that significant progress has not been made toward arriving at a full agreement for the solution of the controversy, he will choose the International Court of Justice as the next means of settlement unless both parties jointly request that he refrain from doing so. Secretary General Ban Ki-moon added at the time that his successor, Mr. Antonio Guterres, had expressed his concurrence with the decision. It was apparent that the decision was taken on the basis of advice given by the United Nations legal advisor. In response, Venezuela expressed a preference for further negotiations. Nevertheless, it recognized that, you will find its words at tab 19, the Geneva Agreements grants to the Secretary General of the United Nations the power to choose the means of pacific settlement of disputes within Article 33 of the United Nations Charter. For its part, Guyana, acting in accordance with the Geneva Agreement, complied with the Secretary General's decision and pledged to engage wholeheartedly in the final year of the good offices process with an enhanced mandate of mediation. And so we reach the final year of that process. On January the 1st, 2017, Antonio Guterres succeeded Ban Ki-moon as UN Secretary General. 1 month later, the new Secretary General appointed the distinguished Norwegian diplomat and jurist Dag Nylander as his personal representative. Detailed terms of reference were agreed, and he undertook to keep the Secretary General fully abreast of the good offices process. Numerous meetings and exchanges took place throughout the year of 2017. This included 3 rounds of intensive, multi-day, formal, bilateral, and confidential meetings in Green Tree, New York, attended by senior delegations, including the party's foreign ministers. Mr. President, I pause for a moment to indicate that we have noted what Venezuela asserts in its memorandum as regards Guyana's attitude and approach to the Green Tree meetings. That claim is neither accurate nor fair, but since it was agreed by all that what passed at the Green Tree meetings would be kept strictly confidential, we have nothing further to add. What matters most, and this is a matter of public record, is the conclusion of the Secretary General. Despite a full year of intensive efforts, there was no discernible progress towards a resolution of the controversy arising from Venezuela's contention of nullity. And so, on January the 30th, 2018, consistent with what he had communicated to the parties on December the 15th, 2016, the Secretary General issued a public statement and sent letters to each of the parties. He announced that he had chosen the court as the next means of settlement. Despite the intensive efforts, the Secretary General had concluded, and the words are to be found at tab 20 of your folder, significant progress has not been made towards arriving at a full agreement for the solution of the controversy. Accordingly, the Secretary General has fulfilled the responsibility that has fallen within the framework set by his predecessor in December 2016 and has chosen the International Court of Justice as the means to be used for the solution of the controversy. End of quote. Mr. President, members of the court, the record is clear. More than 50 years have passed since the signing of the Geneva Agreement. 4 years were fruitlessly spent before a mixed commission, from 1966 to 1970. 12 years were then spent on an equally unavailing suspension of the Geneva Agreement from 1970 to 1982. 37 years ago this week, Guyana and Venezuela jointly entrusted the Secretary General with exclusive, unfettered, and irrevocable responsibility for selecting the means of settlement of the controversy. After 6 years of further discussion between the parties and the Secretary-General's representative, the good offices process was established in 1990 with an enhanced mandate of mediation for the year 2017. That means of settlement ran its course for more than a quarter of a century. It has produced no progress whatsoever. Nothing. Rien. The existence, basis, validity, and nature of the Secretary-General's right to select that process has never been called into doubt. To the contrary, Venezuela and Guyana have repeatedly and consistently reaffirmed the Secretary-General's exclusive responsibility and right under the Geneva Agreement to select the means of settlement. Venezuela has never previously disputed the Secretary-General's discretion to select the means of settlement from those listed in Article 33 of the United Nations Charter. The good offices bore no fruit. In 2018, the Secretary-General concluded that significant progress had not been made towards resolving the controversy. We say that conclusion was reasonable and it was justified. In those circumstances, the Secretary-General was plainly entitled, and indeed, we say positively required by the words of Article 4, Paragraph 2 of the Geneva Agreement to, I quote, choose another of the means stipulated in Article 33 of the Charter of the United Nations. End of quote. Another in the singular. The Secretary-General's choice of judicial resolution by the court was reasonable. It was based on legal advice, and it was and is lawful. The Secretary-General simply could not be expected to go on forever and ever with a hopeless and useless exercise. He did not take an impermissible shortcut, as Venezuela puts it in its recent memorandum. Rather, after decades of futile negotiations and mediation, the Secretary-General concluded, in the exercise of the responsibility, rights, and discretion granted to him by the Geneva Agreement, that the next means of settlement shall be judicial resolution by an independent tribunal applying the rules of international law. The Secretary-General proceeded with the utmost care and deliberation. He had a number of options available to him. He chose this court, the principal judicial organ of the United Nations. That was a first. It was a reasonable choice. It was a sensible choice. And it fell fully within the discretion conferred upon him by the parties under Article 4, Paragraph 2 of the Geneva Agreement. Mr. President, Guyana expresses the hope that the court will not undercut the Secretary-General's careful and deliberative approach, one that was intended to assist in the process of bringing a long-standing dispute to an end. Guyana invites the court to give effect to the Secretary-General's binding decision under the Geneva Agreement to confirm that the Secretary-General acted lawfully and correctly. Guyana has full faith in the court, acting under Article 4 of the Geneva Agreement and applying established principles of international law to confirm that the Secretary-General got it right. Mr. President, members of the court, I thank you for your very kind courtesy and patient attention and ask you to call on Professor Pele to come to the podium to address in more detail the legal basis for the decision taken by the Secretary-General, its lawfulness, and its binding effect, and the jurisdiction we say this court plainly has.
I thank Professor Sandys for his statement, and I now invite Professor Alan Pele to take the floor. You have the floor.
Thank you very much.